Hello and welcome. We are glad to have you with us today for this webinar on Export Compliance Basics. I'm your moderator, Jenny Alton from the New York Small Business Development Center Central Office. This webinar is brought to you by the International Trade Initiative of the NYSBDC. The NYSBDC is a U.S. Small Business Administration resource partner with free advisement, education, research, and advocacy services offered across New York State at higher education institutions and outreach offices at other locations. Our funding is made possible from the SBA, New York State, and our host campuses. I am happy to introduce our presenters to you today. We have our own Dr. Mercedes Sanchez-Moore, Director of International Trade, from whom you will hear first. And then we are very pleased to feature John Yormick, Esquire, Managing Member at Yormick Law, LLC, and Rachel Small, Esquire, Counsel at Yormick Law, LLC. So you know we are recording today. We will share links to a copy of the slides and the recording in a follow-up email. Attendees are muted and will not be on camera. Your chats will be visible to me and to our presenters, and closed captioning is available for this session if you need that feature. Now, if you have questions regarding today's material, please don't hesitate to type them in the Q&A or the chat as they come up. I'll be monitoring both. You can open the Q&A box and the chat from buttons at the bottom of your Zoom window screen, and we will address questions throughout the presentation. And that takes care of all of my housekeeping. So I am going to switch our slides here, and you will now hear from Dr. Mercedes Sanchez-Moore.
I am going to provide a brief introduction about the New York Small Business Development Center and the services of our international trade program. Next slide, please. The New York SBDC, as Jenny said, is a partnership of the U.S. Small Business Administration, SUNY, the City University of New York, New York State, higher education institutions, and the private sector. The SBDC provides one-to-one business advisement, training, and research in support of entrepreneurship and economic development for the state of New York. Next slide, please. The International Trade Initiative is a special program within the New York SBDC network, which is housed and part of the SUNY network of 20 regional centers and 72 outreach and satellite offices. That means that 98% of the population in the state of New York is within 30 minutes of an SBDC service location, and you can see in the map all these little yellow dots. Those are the centers and satellite offices that we have. Next slide, please. The New York SBDC International Trade Initiative supports SBDC clients statewide with expertise and experience on international trade and trade compliance. We also provide SBDC staff with professional development, increasing trade advising capabilities statewide. All of our services are free, customized, and 100% confidential. We help small and medium-sized companies become globally competitive by providing export development and import operation assistance through one-to-one trade consulting, market research, and innovative training, such as this, and links to additional export resources provided by our partners, which are very important to our program: Global New York, the U.S. Commercial Service of the Department of Commerce, the Small Business Administration, Exim Bank, and other public and private organizations. Next slide, please. The New York SBDC can help your business become a successful competitor in foreign markets by helping you plan and implement your export strategy. We are available to assist retailers, manufacturers, high technology, and even service companies with export planning and other areas such as export readiness reviews, export business plan, targeting international markets, selecting sales and distribution channels, legal considerations and licensing, logistic procedures and documentation, market research and trade statistics, and international financing options. Next slide, please. The SBDC is the only public agency that helps companies with basic questions about import operations. We provide education and assistance on the basic of importing. We also help companies classify their goods and share updates on tariffs and the International Emergency Powers Act, IEEPA tariff refund process. We always recommend working with a licensed custom broker, and we connect our clients with attorneys and custom brokers for these matters. We advise clients on import regulations affecting specific products, including foods, with strict FDA requirements and certifications of overseas facilities. Again, this is only advisement, and we recommend consulting attorneys for this matter as well. We also guide businesses on logistics and importing documentation. In addition, we assist with market research and trade statistics, as well as access to international financing solutions. Next slide, please. In this slide, I would like to provide some information on why US companies should export. Many companies think that the US market is big enough for them, but actually 95% of global buying power is outside of the United States. Forward-thinking small and medium-sized businesses can tap this demand and boost revenue through exporting. Every year, US firms export over $3 trillion in goods and services. Exporting works for businesses of all sizes. 97% of US exporters are small and medium-sized enterprises, and 67% has fewer than 20 employees. There are many benefits of exporting, and some of them are: exporting companies grow faster than non-exporters, they are more resilient to economic downturns, and they are 8.5% less likely to go out of business. They gain more diversified sales base, creating more revenue streams, the growth opportunities and higher productivity, and they also see greater innovation in product design and application. They are exposed to whatever is happening in the rest of the world. Next slide, please. And now it's my pleasure to introduce the first speakers of today's program, attorneys John Yormek and Rachel Small from Yormek Law LLC. Please go ahead. Thank you.
Thank you very much, Mercedes, and thank you to NYSBDC for the opportunity to present today on export compliance basics. So I'm John Yormek. I am the founder and managing member of Yormek Law LLC. I've been an attorney for 35 years, and for about the past 25 or so, have focused on international trade, both imports as well as exports and international agreements. Joined today by my colleague, Rachel Small, who will introduce herself briefly in a moment here. We welcome the opportunity, as always, to talk to companies about export compliance, and I've given a lot of presentations over the years, and one thing I like to say about export controls and compliance is, there's the board game Monopoly, and there's a lot of rules with Monopoly. You usually don't want to just sit down and start rolling the dice and try and play that game. You want to have the rules explained to you, or you read the rules. And that's what we help clients do, is to understand the rules. So we'll go through that in today's presentation and provide some practical insights and the so-called war stories on sometimes things, what not to do in order to successfully export in a compliant manner. Rachel, I'll turn it over to you.
Good morning, and thank you for joining us. I am an attorney originally from Australia. I just thought I'd address that up front because people sometimes spend the entire presentation trying to work out what my accent is. Originally from Australia, I've been here in the US for 20 years. 16 years of that I've been involved in export controls. And previously in Australia, I worked for the Australian government doing criminal law. So I have a combined experience of 25, 30 years, like similar to John. And I have been delighted to learn more about export control since I've been here in the US. I had the opportunity to work for DDTC at the State Department, Homeland Security as well. And then I spent a couple of years doing sanctions at OFAC before going back to industry and also working as in-house counsel. It's my pleasure to be with you today. Thank you for joining us. I guess I'll get started. The goal here is not to turn anyone into an export controls expert in 1 hour. Instead, we want to give you a practical framework, something you can actually use when you go back to your business tomorrow or this afternoon. I would like to move along here on the slides, please. I think there's a disclaimer slide next. Thank you. I'd like to take a quick read of that.
This is simply for the benefit and requirement of our malpractice insurance that we're not providing any legal advice, and certainly things move quickly in trade compliance. So we're providing you with what we understand to be current information, but it's always best to consult first. Look before you leap. Next slide.
I came up with this slide because I do think that export controls people and compliance people generally take themselves very seriously, and I think that is a great trait to have when you're in trade compliance. However, we do need to remember that, it still is, these are widgets, not brain surgery, and it's good to keep everything in perspective. Most things are reversible, errors can be fixed, and there's always somebody to help you get through this. Next slide. This is the agenda. I believe it was also in the blurb that went out as well, but I just wanted to put that up there again to see exactly where we're headed this morning. And we're going to start with the basics, what the EAR is, and how it fits into the broader US export control system. Then we're going to walk through classification, what an ECCN is, and how to determine it. From there, we'll move into licensing, when you need one, how to think about it, and wrap with enforcement and risk around that whole area. If you walk away with one thing today, it should be this. Export compliance is a process. And once you understand the process, it becomes more manageable and not at all overwhelming. Next slide. First of all, before we get into the EAR specifically, it's important to understand the broader regulatory landscape. There are really three main regimes. The ITAR, which covers defense articles and is administered by the State Department. The EAR, which we're focusing on today, which is administered by the Department of Commerce, and the Office of Foreign Assets Control, otherwise known as OFAC, and it handles exclusively sanctions. And you may or may not have heard of DFARS, CBP, HSI enforcement, and USAO, and of course, we can't forget the FBI. In practice, just before we move on to the next slide, I wanted to make the point that in practice, having been a licensing officer and a compliance enforcement officer at both the Department of State, administering the ITAR, and also at OFAC in Treasury, I wanted to make the point that in practice, these agencies do not operate in silos. A single transaction can trigger all three. That's where a lot of companies run into trouble looking at one regime instead of the risk across the full spectrum of the regulations. And in practice, the agencies all work together and collaborate on single transactions that are under review. Next slide. Why all of this matters. So why should you care? At a high level, export controls are about national security and foreign policy. But at the company level, the drivers are much more practical. Avoiding penalties, protecting the company's reputation, and preserving access to government contracts. We've seen companies lose export privileges entirely, which for some businesses is effectively existential. So this isn't just a legal issue, it's a business continuity issue.
I like to say that it doesn't matter how many dollars are generated on your exports. It really matters how many dollars you keep in the bank from those exports and are not paying over to the government, to outside consultants, attorneys, to defend against investigations and penalty enforcement actions.
Next slide, please. So the fundamental question, what are export controls? Export controls regulate the movement of goods, software, technology, and even services across borders, or importantly, to foreign persons. One key concept is dual use. These are items that have both civilian and military applications. And the big distinction is the ITAR covers defense-specific items, and the EAR covers dual use and less sensitive military items. So those are the two buckets, if you will, of in terms of goods generally. That line isn't always obvious, and getting it wrong is one of the most common and most serious mistakes companies make. Next slide, please. Introduction to the EAR. The EAR is intentionally broad, and I'd like to emphasize that. It doesn't just apply to exports from the United States. It applies to US origin items located anywhere in the world. Foreign-made items which have sufficient US content. And increasingly, foreign-made items produced using US technology. So you can be a non-US company operating entirely outside the US and still be subject to the EAR. The extraterritorial reach is something a lot of companies underestimate, and they can run into trouble there. That's the point that I want to make there. And next slide, please. What is subject to the EAR? Subject to the EAR includes commodities, software, and technology. Items in the US, US origins worldwide, and certain foreign-made items incorporating US content. Exclusions, international traffic and arms regulations items, those subject to the ITAR. Publicly available information. So if you can find the information readily available on the internet, then it is not controlled for export, as a general rule. Of course, there's always exceptions to that. This is one. I was going to say, go ahead, John.
Sorry, Rachel. I just wanted to mention that the reason subject to the EAR is shown in quotations is because that is actually a defined term within the Export Administration regulations, within the regulations that we're speaking on today. So we didn't burden you with a lot of legal citations for this and clutter up the slides any further than the content we did provide. But I would encourage everyone to focus on that particular definition. We've highlighted aspects of it here, but you really need to understand and have your foreign customers, your affiliates, your subsidiaries, et cetera, overseas also understand what is subject to the EAR.
I did have one additional point. Thank you, John. That's an excellent point. I wanted to make the point that this is one of the most important threshold questions. Is your item even subject to the EAR? If the answer is no, because it's ITAR controlled, for example, then everything changes. We often see companies skip this step and just jump straight into classification. That's a mistake. The first thing to decide is jurisdiction comes first. Even before you decide to jump into trying to classify your item, you need to know whether you're classifying it under either the EAR or under the ITAR. That was the point I wanted to make specifically. Next slide, please. Let's talk about who enforces all of this. BIS is the primary agency for the EAR and also for dual use items. However, they don't act alone. The Directorate of Defense Trade Controls, DDTC, controls defense articles exclusively. And then overarching agency control is also assigned to the Office of Foreign Assets Control. That's the Treasury Department. And they have country-specific and sometimes item-specific programs. And others like energy and defense in some specific contexts. From a practical standpoint, that means complexity and sometimes delay because multiple agencies may need to weigh in on a single license application. Next slide.
Well, and before we leave this slide, if I can, excuse me, Jenny, if I can just mention that BIS, excuse me, has a division within BIS called the Office of Export Enforcement. This is not to stir up, this is not scaremongering. This is to provide you with information. The Office of Export Enforcement has special agents who are law enforcement officers and investigators. They are scattered throughout various field offices. There's a field office, New York field office is located in Staten Island, and agents from that office, fan out throughout the state for not only investigations, but also outreach visits to get to know companies, to get to know the technologies, the products, the markets, and even your workforce as part of educating companies on export compliance matters. And I would have to say that Rachel and I are stepping in because one of the OEE special agents who was initially tapped to provide this presentation was unable to do so. So we're happy to step in for one of those agents who I know through many positive communications that we've had in representing various New York companies. But I did want to mention that BIS, when it comes to enforcement, it is local. This is not all driven out of Washington. Thank you.
In real life, this interagency process can slow things down significantly sometimes, especially for sensitive destinations or technologies. So one practical takeaway is to build lead time into your transactions. If you're shipping to high-risk jurisdictions or dealing with advanced technology, assume delays in interagency review of the transaction.
Yeah, and this is really important to understand as well from a commercial standpoint, because you cannot have the sales team, shipping team make promises about delivery times. You want to make sure that your terms and conditions account for this contingency, particularly where you know already that some of your goods are controlled and that they will require an export license in many instances. So build that in so that you're not hit with penalties for late delivery, that you're not receiving order cancellations due to delays. Build in this contingency in your commercial terms.
Next slide, please. BIS Mission and Enforcement Authority. The BIS mission is to advance U.S. national security and foreign policy interests, ensure strategic technologies are not diverted, promote lawful exports. We have a licensing authority. They also have multiple entity list designations where certain companies or individuals have been tagged as being high risk, and also export enforcement.
And let's just for those that may not be familiar with all the acronyms that we're using to shorten the slide content a little bit. So we have there in that second sub-bullet entity list. That's the primary list where parties of concern are listed by BIS and restricted and generally always require a license. The MEU list is the military end user list. It's one of the newer lists, been around for about 6 years now, since 2020, primarily focused on Chinese parties. Then you have the UVL, the unverified list. This is a list where certain entities, again, a lot of Chinese parties are on the UVL. You can still do business with a UVL designated party. However, you have to obtain a statement prior to the export. So it's a documentation, a paperwork requirement. It cannot be overlooked because shipping without that statement already in hand is a violation. But a license is not required. So it's a self-documentation, and the regulation sets forth the statement that is required. And we've worked with many clients to obtain a valid UVL for their compliance file before that export occurs.
The only other point I would make is that BIS enforcement has become much more aggressive in recent years, especially in particular areas like semiconductors, AI, and advanced computing. There's a lot more investigations, more coordination with Department of Justice, and more significant penalties. That was the only other point I wanted to make. Next slide, please. This is where things start to get technical. The Commerce Control List is structured. Well, first of all, it's found at the link there that we've put for you, which is 15 CFR Part 774, Supplement Number 1. You can take that link and look at it in detail yourself if you wish. It's broadly categorized in 10 categories, and they are numbered 0 to 9. Each of those categories is divided into product groups, and they are numbered A through E. For example, category 3 is electronics, and beneath that category we have a product group A. All of A category relates to systems within the broader category of electronics. Understanding the structure is essential before you begin the classification process. Most classification errors occur because users skip the category/product group logic. And sometimes it's easy to jump in where you think it's going to land without actually working straight from the top, making sure you're actually within the correct category. I don't have any other comments, John?
Nope, next slide. Thank you.
We put in here an example flowing on from where I was mentioning category 3. You can see there at the top left the number 3, which is the broad category for electronics. And then you see next to the 3 an A, and that is systems. And then you have within that 3 digits possibilities as they're listed out. But the main things to pay attention to is 3 and the A. And then you get into more of the more technical classification. Within the CCL, you can see it's shown just as you see it here. And then another thing to note is the reason for control. You can see that again on the top left, the NS for national security, RS for regional security, MT for military, and
No, missile technology.
missile technology, sorry, and NP for
Non-proliferation.
and AT anti-terrorism. So
I passed the test.
Yes.
I get a gold star for the quiz on reasons.
I had
for
a mental
control.
blank there. I think I need more coffee. So you can see here that under the control, they have each item is then being assessed, and you can see under the controls list, they have itemized some parts, some systems. For example, you can read there, it says national security applies to monolithic microwave, integrated circuit, amplifiers, and there are many cross references within the CCL. And that's sometimes where it gets tricky. One, national security, you can see applies to the entire entry. National security, I would say, is probably the most common reason for control, which is understandable. And regional security applies to certain elements there. Regional security is often related more closely to what's happening politically. Sometimes it relates, for example, to where there may be tensions, a war going on or something. And that's why that can be applied there. And you can see all the subcategories as well. Without getting too into the weeds, we could probably spend another hour on that one alone.
Yeah.
And each character matters, I guess, is the only other point I wanted to make on this slide. A small mistake in classification can completely change licensing requirements and potential exposure.
Yeah, I think, this is a good example of why you need to read the CCL entries very carefully and completely. And this is an example, 3A001. This is a top level export control, if you will. Maybe we next time around, maybe we'll contrast this with an entry such as 3A991, which is going to be a low level. So as the third numeric, alphanumeric character changes from 0 and increases towards 9, it's usually a lesser control. So usually 3A991, I believe, is simply controlled. The reason for control is anti-terrorism. So it's a much lesser control, less restrictive control. But again, that's understanding the structure of the CCL. Excuse me.
Okay, next slide, please. Oh, here they are. The reason for controls, driving licensing requirements, as we went through them, the non-proliferation one there, of course, and anti-terrorism. It's important to always tie the ECCN, the reason for control, to the country chart. I don't really have any other comments on the country chart at this point.
Nope,
but
we probably need to pick up the pace.
okay, next slide. Now, the export classification number, we have the structure. I think we've already gone through that. So as we said, we've got the format. The example here is 5A, the category, the product group, and the specific control entry. I think we already made that, that point there. So next slide. The infamous EAR 99. EAR 99 is often misunderstood. It's not a free pass. It just means the item is not specifically listed on the CCL. You still have to screen parties, consider the end use, evaluate the destination country, and we've seen enforcement actions involving EAR 99 items because the issue wasn't the item, it was the customer's use of the item.
Yeah.
Yeah.
On that point, so I said we need to pick up the pace, but I'll provide one quick war story. So we recently concluded a voluntary self-disclosure to BIS for a company where its scientific research equipment is in fact EAR 99. And however, that equipment was being purchased, and the end users were several universities and research centers in China, many of which were parties designated on the entity list. And they landed onto the entity list for various reasons, including research being performed for the Chinese military, as well as a nuclear program and quantum technologies programs. So even items such as these, again, in this case, it was basic research equipment used in university labs and other research facilities. It can trigger an export license requirement. Now, we successfully concluded that matter with BIS just a couple of months ago without a civil penalty being enforced, which quite honestly, in all my years' experience, and I prepared the client for a monetary penalty, a civil penalty in that case, because I viewed some of those as being somewhat egregious when you're not flagging a shipment going to a military medical hospital in China. That should be a red flag, and we'll get to that shortly. But I do want to mention that that is one way in which an EAR 99 item can be subject to a license requirement. Again, look before you leap.
Next slide, please. How to determine your ECCN. Since we're picking up the pace, we won't go into this in too much detail, but it's a whole classification process. But in order to do the process, you do need to make sure that you have product specs, engineering input, and a disciplined review of the CCL. Legal alone can't do this, and engineering alone shouldn't. The companies that do this well build a collaborative process between compliance and the technical teams. I think that's all I had on that one. Any comment, John?
We do have a question before we move on to another topic. One person wants to know, how do you actually verify end customer use for EAR 99 items?
Well, generally, you're going to, as part of your company's compliance practices, you're going to want to have that party sign off a certification, generally referred to as an end user certificate or statement, that confirms to you, and when we draft them for clients, we also draft them so that certification is not only to the exporting company, but also to the Department of Homeland Security, to U.S. Customs Border Protection, BIS, etc., all these government agencies. And the reason we do that is certainly because we want that certification to our client, but also if that certification turns out to be false, we can provide that to BIS, for example, and then they can take further action in order to investigate that company or what have you. It can be a bit of a leap of faith. You really want to have that document signed by someone in authority, not simply the purchasing representative of that foreign party. It should be someone higher up with the authority to bind the company to those certifications. And you also need to do your due diligence with respect to that company. Everyone can poke around in 5 minutes and see, is there a valid LinkedIn profile? Is there a paper that the person presented at a conference that links that individual to the entity that they are signing off for? There is a BIS form as well, the BIS 711 form, but it's a government form and it doesn't cover sanctions. So you get to, as I like to say, deal yourself your own good hand when it comes time for export compliance. So we would suggest that you use an end-use and user statement on company letterhead to obtain that certification.
Excellent. Thank you so much. And
one
go
last
ahead.
thing, Jenny, on
Yes.
that point, I should mention that in any inquiry or investigation, it's the first document that BIS asks for, whether it's an email from an analyst, whether it's an agent contacting the company. It's, where is your end use and user statement? We need to see it.
Thank you. Was there anything you wanted to add on that, Rachel?
No, I think
Okay.
you've covered everything very well. Thank you.
Before we go on, Mercedes, there is a question for you in the chat. So I will let you handle that one while John and Rachel continue with their presentation. All right.
Self versus BIS classification. So you can self-classify, and most companies do. You do, however, have the option to request what's called a CCATS from BIS, which is a Commodity Classification Automated Tracking System, particularly useful for ambiguous or competing classifications, high-risk technologies, and items made up of various distinct items. This can be a valuable risk mitigation tool, especially if you're dealing with sensitive technology or uncertain classifications.
Yeah, quick example on that. So on that last sub-bullet point, we have a client in Rochester that has communications satellites that are on Earth, and some of those are sold to the military, including for militaries around the world. So it's kind of the typical dual use, this type of item. But that was being sold as a portable version with a trailer and other equipment attached. So not everything was subject to the EAR under a particular ECCN. So we believed that it should be classified under a particular ECCN, but advised the client that we should obtain a CCATS ruling, classification ruling from BIS in that instance. And it's a good thing that we did, because BIS did not agree with our analysis and classified that unit differently. We knew there was that chance. It wasn't a critical difference from a commercial standpoint, but having that classification in hand really helped clarify things. So there was some ambiguity with competing provisions, the competing ECCNs, and it was complicated because of the number of items in the particular unit. So I think that's a good example of where you would want to go to BIS, where there's more complexity than what you might be able to put together through your self-classification analysis. Thank you.
Next slide, please. Okay, let's talk about license requirements. So once you have your ECCN, the analysis just doesn't stop there. You still need to look at the destination, the end user, and the end use, and the reason for control, which we did discuss a few minutes ago. This is the core workflow under the EAR. Classification is just one step. The first step, and a very important one, I would say the most critical step, but the actual license requirement determination is the next step.
Yeah, real quickly, parties to the transaction is in quotes. Again, that is a defined term within the EAR. Back in 2020, BIS published in the Federal Register a clarification with respect to that definition, really calling attention to the concept that parties on the entity list, when they are involved as a party to the transaction, a license is required. A party to the transaction, you see there, is the purchaser, any intermediate consignees that would take possession before arriving at the end user's location. So again, those are all the parties of concern in the transaction that you need to be aware of and screening for license requirements.
So next we're going to look at additional license triggers. Even if something is EAR 99 or otherwise low risk, you can still need a license based on who you're dealing with or how the item will be used. So compliance isn't just about the product, it's about looking at the entire transaction from beginning to end. And that is how BIS will look at it if it comes under scrutiny. So that's all I had on that one. If you had anything else on that, John?
No, I've already talked about that.
License applications and CCAT's ruling requests all are submitted via what's called the SNAP-R system. SNAP-R is short for Simplified Network Application Process. It's a BIS electronic filing system. It's required for license applications, CCAT's requests, and importantly, there is no fee to use it. Accuracy in your submission is critical. Errors lead to delays or denials. If your description is vague, inconsistent, or incomplete, you're going to see delays or a denial, or quite possibly a call from the licensing officer himself or herself to directly ask you for clarification. So when you put your phone number in there, do be prepared to receive a phone call, usually within the first day or two of submitting your request. That's all I had for that one. In terms of license application requirements, there's a detailed item description, the ECCN, and dual end user and other parties to the transaction, as we discussed, and supporting documents, including a letter of explanation, which can be key. The letter of explanation is really your chance to tell the story of the transaction, and also be sure to include in that letter of explanation reference to all the parties that are involved in the transaction. From a licensing officer perspective, that is what the licensing officer will be looking to do, is to correlate the letter of explanation to the application itself to ensure that all the parties listed and their respective roles are explained in the transaction.
And one other thing that you want to include in your letter of explanation is reference to any other licenses that have been issued to your company for the same products or involving the same parties to the transaction, because there's already been some vetting done by BIS in those scenarios. So you want to try and help your cause on your next license by referencing past successful license applications and issuance of those licenses.
Next slide, please. Enforcement and penalties. Let's talk about risk. Penalties can be significant. Civil fines, as we've said here, up to $374,174 per violation, or 2 times the transaction value, and denial orders, which will severely curtail export privileges for the company. And importantly, this is a strict liability regime. Intent is not required for civil violations. I think the best way to explain strict liability would be kind of like road rules. Just because you didn't know you had to use your blinker in that situation does not absolve you of getting a ticket. That's why compliance programs and documentation matter a great deal.
Yeah, and just one quick note here under voluntary disclosures. So if you find that you did have a apparent violation, you generally want to self-report that. You want to go back 5 years because that is the statute of limitations, to make sure you didn't have similar violations. But just because you have a written compliance program, please understand that it is not a mitigating factor. That's a myth. That there's a misconception to believe that having a compliance program is a mitigating factor. In truth, under the penalty guidelines, the BIS penalty guidelines, that is simply a factor. It's a general factor. Well, if you have one, that's fine, and that's what's expected. If you don't have one, it could be a mitigating factor, but don't expect to get, big credit because you have a 50-page, well-documented compliance program. And remember, your written compliance program needs to fit the company, needs to be practical. It can't be something that sits in a PDF that nobody ever reads, or sits on a shelf and collects dust. It's a living and breathing document. So the last thing you want to do is provide BIS in your disclosure something that hasn't been updated in the last 5, 6, 7 years, something that doesn't address Russia sanctions and Russia transshipment risk since the war began 4 years ago. So think of it as a living and breathing document that has to be updated constantly. And on cue.
Diversion, evasion, and transshipment. One of the biggest enforcement priorities right now is diversion, especially through third-party countries. So you need to watch for red flags. The following countries in particular have been identified as BIS as posing transshipment risks. So we just included this list so that if one of your customers may be receiving goods and they're going to be shipping it by these countries, and there is definitely a red flag and will draw attention from your licensing officer and additional scrutiny. So I have
And something that should again is a red flag, should draw additional scrutiny, should cause your company to slow down the order and fulfillment process.
Next. We included here a non-exhaustive list of red flags. I'm not going to read through them all, but I guess some of I would say the higher, more common ones are unusual routing, third-party intermediaries, payment mismatches. If something doesn't make sense commercially, it probably doesn't make sense from a compliance perspective either. And
Yeah. Sorry, Rachel.
That's all I have on that one.
And some of these red flags that we include are kind of the updated red flags that BIS had issued since the start of the war in Ukraine, in particular. But something that commercially doesn't make sense. Be objective. If you receive a potential either an RFQ or an actual PO, and it's a significant order compared to what a typical order looks like. Don't treat it as a windfall, and this is great. We usually get $20,000 orders for our widgets, but now we've got a $150,000 order for our widgets. Ask questions. That's a red flag because that may be, in fact, an illicit procurement network finding a willing U.S. company to export, a bulk shipment so that then they can be diverted to other parties, whether it's in North Korea, Iran, Chinese entity list parties, etc. So make sure your sales folks understand that as well, because sales and compliance sometimes mix about as well as oil and water, but you need to bring them into the fold for sure. That's all I have on that. And with that, I think we're pretty much right on time.
Thank you for such an informative presentation, John and Rachel. It's been great. And now we will accept questions from the attendees. If there is anything that they haven't added to the chat, please.
All right, so go ahead and put those questions in the chat and or the Q&A box, and we will be glad to get them answered.
Well, we did our best to cram a lot of information into a short period of time. Hopefully, we provided some useful practical information and tips, as well as the slide can provide some reference materials that everyone can go back to, especially for those companies that are not seasoned exporters. That might be at the beginning stages and working with the SBDCs on their export strategy.
Yes. And so I would love to have the three of you talk about that, because that is a question I always like to ask for the people who are brand new to this and have come today and are like, wow, that's a lot. Where do they start? Let's have you talk about that.
I think I think export compliance can be overwhelming, but at its core, it's a very structured process. And so once you become familiar with the process, it's always the same process that you need to go through. Eventually, it does become routine. The first step is always determine jurisdiction, whether it's EAR or ITAR. Second step is always classify the item, evaluate the entire transaction, as we mentioned, for identifying every single possible party to the transaction, and then importantly, to document your analysis so you have a record. And if you build that documentation and that process into your operations, you significantly reduce your risk, and then you should be fine should you be unfortunate enough to come under scrutiny.
Give yourself good cards to play is what it comes down to. But I would say the place that you want to start is ESBDC and the other agencies, partner agencies with Global New York, SBA, et cetera. There's a ton of resources available. U.S. Commercial Service, I should mention as well, not leave them out. And we've worked with all of them over my career in private practice. There's a lot of valuable free or reduced cost services that can be provided. You don't want to start with the lawyers. There's no need to start with the lawyers. All right. We can help you through licensing, through agreements, through, now what should we do? But tap into all of the resources that the state offers and that are complemented by the U.S. Commercial Service at the federal level as well.
Thank you for that, John. That is very generous of you to recognize the existence of public resources and of course to start with, and then if, as you said, if they require licensing, there is some problem that they encounter and were contacted by BIS, etc. And actually that is when I say that I make the referrals to attorneys. So this is wonderful. Thank you, John.
Thank you for that. All right, so we have a question about a UPS tool that there apparently is for denied parties. And is that sufficient enough, or do you need to go to government sites as well? Are you familiar with that tool that this person is referring to?
Generally, yes. But I don't handle our, we have a FedEx account at our firm. I don't handle that. So I assume that it's tied into the government list. And one thing that maybe we overlooked and we will provide after the presentation is the link to the consolidated screening list that companies can use to screen. It's always best to do your own homework. And I would often, and I've represented freight forwarders in BIS penalty cases. Their first priority is not to handle a customer's export compliance. They're really good, especially the big three carriers, FedEx, UPS, DHL. They're terrific at getting goods from point A to B. They're not so good, and you can find their penalty cases as well, where they failed to flag license requirements and things of that nature and face multi-million-dollar penalties in their cases because those violations are in the dozens, if not hundreds. So that's not a knock on those companies at all. That's just the reality, is that their primary focus is getting your goods to the export destination. It can be relied on, but I would back it up with your own homework. Trust but verify.
I've just dropped that into the chat.
Oh,
okay, great. And I'm just going to recopy that and make sure it goes out to everyone.
That Mercedes did as well.
Here we go.
yes,
Okay.
I did. place the search engine site from the same source.
It is the correct source because actually there are
Yes.
a lot of different links out there. So I think it's important to make that
And
point.
Jenny also had another one. Oh, she's
No,
going to
that
play
I
the
just
same.
recopied Rachel's.
Okay, okay.
Yes.
Okay.
And
All
the key
right.
is, excuse me, the key there is, as Rachel mentioned earlier, is document. So don't do the search, see no results, and leave it at that. Take a screenshot, print that to PDF, print a hard copy. That becomes your documentation. Everyone from the government is from Missouri. Show me. Okay, so you need to have that documentation in order to tell your compliance story.
Thank you.
And check
Now,
addresses too. Check addresses because a lot of companies are co-located with the bad guys.
excellent tip. And I do want to remind everyone that those services of the SBDC are offered at no cost. So as you are getting into exporting and the things that go along with it, you are able to get assistance at no cost to your business, which I know is a big deal for a growing business. Costs add up very quickly. So, Mercedes, could we have you drop your email address into the chat for people who might be interested in getting in touch with you for some assistance?
Yes, ma'am. I was writing it right now because I saw the text.
You read my mind. All right.
Yes.
Thank you. Now, on EAR 99 items, besides the obvious red flags checklist, is there, so let's see, this person says an order export dollar amount where due diligence, i.e. deeper dive, becomes more important. So is there some threshold that you reach at, 10,000, 50,000, something that kind of makes that even more critical?
No, value doesn't matter. Red flag is a red flag. And just like the drug cartels are trying to find folks to bring things into the country, there might be tests. Okay, so you have to be wary of something out of the ordinary. If you see red flags, the company that is purchasing or has inquired about our products. We've taken a look. They don't have a website. We've taken a look. We can't find anything about them, or what we do see is not really what they do and what we provide or sell don't match up. Those are red flags. Doesn't matter if it's a $500 shipment or a $50,000 shipment. You have to clear that red flag because they might come back 2 weeks later and say, well, now I've got a $10,000 shipment. Thanks. Maybe it's a sample, maybe it's legitimate, but if you see red flags, act cautiously, potentially decline the sale. A $500 sale isn't going to make or break any company, even the smallest of businesses. So you have to be willing to walk away. That's what protecting national security is all about. And if my friend Chris O'Neill from OEE was giving this presentation, I'm sure Chris and his colleagues at OEE would be saying the same things.
Yes, and I was going to add, we did have a very nice webinar in February called How to Know Your International Buyer. And we do have slides and recordings about that, so you could email me and then I'll try to send a presentation about. We talk about red flags and we talk about don't let this happen to you, etc., etc. All the due diligence and how to conduct screening and the important questions: who, what, where. So people are aware of when to be careful and if things don't look right.
Yes, and we can even include that in the follow-up email, Mercedes, so we can make that easy for people to be able to access. Okay, so I know that as you went through this presentation, Rachel and John, you kind of highlighted some different areas where people tend to run into trouble. I would love if you could just kind of here at the end give a little recap of some of those that, you know, those things to watch out for, things to be very cautious about, just in your experience where you've seen businesses run into trouble.
Rachel, be my guest.
I have one, having been a licensing officer, not at BIS, but at DDTC and also at OFAC, that the letter, the cover letter, which is your chance to explain the transaction to the licensing officer. As I mentioned as we went along, one of the things that the licensing officers must do is identify all parties to the transaction. And a really, easy mistake to make, but it will prompt a call or an email from the licensing officer, is if you have not mentioned a party in the letter and then you do put them in the actual body of the application. It's kind of it's rather irritating to licensing officers. You hear them complaining about it because you think you have, everybody that's in the transaction, and then, you look in perhaps the purchase order and there'll be another company. And sometimes that company isn't even mentioned in the letter or the application. And suddenly you have to go back and to the applicant and ask them what exactly is this company's role in the transaction, and why did you not include them? And often it's because the applicant just simply didn't think they were important enough, or sometimes it's just an oversight. But every single consignor, freight forwarder needs to be mentioned.
And I would just add to that, again, in the context of your license application, make sure if it's your first license application, you're getting guidance. We have a client in Syracuse. They brought in someone to their company who actually worked at the U.S. Attorney's Office in Syracuse as a paralegal. And she thought that she knew how to submit the license, no questions. And her error was that in reporting the value of the transaction, she undervalued it because she was only valuing the items that were subject to a particular ECCN. And transaction value, I had to explain, means the $500,000 sale. It doesn't mean the $300,000 of equipment that is subject to a particular ECCN. So that caused delays. That then caused tension in the customer relationship. It cost the company time and money to go back and have to resubmit that license application correctly. So try to get it right the first time. Get the guidance that's needed when you are in need of a license, even for your EAR 99 items.
Guidance, that's that's the correct word. I have seen also companies that got in trouble because they didn't even think about it. They receive an order for for their transponders, and their transponders were used in appliances, but it happened that they were included and they have a specific ECCN, etc. So BIS, they receive a call from the office of BIS. So again, before you do anything, just try to get information. Don't just rush into the transaction just because you have an order, and also it's very important also these days to make sure that your goods are not going to be transshipped. That means that originally they are going to go to a destination, and from that destination somebody else is going to take over, and they're going to send it to some place that you don't know, and it's actually not allowed by the US law because there are sanctions. So those are the things that I would mention, that I have seen from my clients directly, getting into trouble.
Yeah, if you see something, say something internally, and if necessary, externally. You have to, probably the best training any company can provide is red flags, spotting red flags.
Thank you. Great advice. We have a question. Oh, go
Sorry,
ahead,
Jenny.
please.
The way my mind works and a lot of years of doing this, do not overlook two things. One, software that might be part of your export item. That may need to be separately classified in some instances. Secondly, we're in New York. The Canadian border is to the west. If we're in Buffalo, to the north. If we're up in North Country into Quebec, hand carry items are an export. Just because something is packed in someone's bag doesn't mean that, a salesperson taking an item that's export controlled and is flying internationally, but driving up to Toronto to do so instead of they want to avoid JFK or Newark. That's an export. And you have to, view it as such and not as baggage. Now, there is a baggage license exception. We didn't get into license exceptions, but again, that's where guidance can come into play. But don't overlook those two areas. We've seen that overlooked often, or more times than not, or that it should be.
Love these tips, John. And yeah, that's why we have you and Rachel here, and of course our own Mercedes, because the voice of experience can definitely save people a lot of trouble when they hear these tips up front and know what to watch out for. So thank you so much, all of you.
All we're doing is trying to avoid stress. That's it. Trying to lower everyone's stress level.
Absolutely.
Be helpful.
Mm-hmm. So we have a question from an attendee who says, when you file with AES Direct for an export ITN number, do they automatically check denied parties and shipment addresses?
No, that's
Okay.
up to you. Do your own homework. And know that that ITN is that information is being accessed, shared, reviewed every day by EIS analysts. And if it happens to involve an ITAR controlled export, Rachel, I assume DDTC is reviewing the AES filing as well.
I wouldn't guarantee that, but definitely they do receive a lot of referrals from BIS. So I think the communication channel goes via BIS.
Thank you.
No, those are not screened. That's your reporting requirement, as you know, but the screening has to be performed by you as the exporter of record prior to that submission.
Thank you. As we wrap up here today, I am going to just quickly share Mercedes's email address on screen again for anybody who hasn't already gotten that. And I displayed our presenters' emails for a while there too. So everybody's emails will be in this recording as well. And let's see, are you seeing the slide now, Mercedes, with your email? Perfect. Okay, I just wanted to make sure I got that back on screen. So I believe we have gotten all of our questions answered for today. So before I wrap things up here, I just want to say that we will have a survey that will show up at the end once I shut things down. And we would love to get your feedback on today's presentation and other things with which we can help you here at the NYSBDC. Other things you need for your business, whether it's focused on things particularly to do with international trade or other aspects of your business. We love getting that feedback from our attendees. And so, any last tips, parting words today from our three experts?
My advice is search before you're going to do something. Don't just jump. Search for information. Reach out. Contact the SBDC, any of the other public agencies, but don't just assume that doing business internationally is the same as doing business domestically, because that is not the case, and you can get in unnecessary trouble.
Thank you, Mercedes. John, Rachel, anything else to add?
Really just along the same lines. Just be prepared. Understand the rules. Get help if you need to have some guidance on understanding the rules and slow down. Don't let sales drive the compliance. Oh, that's going to be okay, or we haven't done that in the past. Well, that's a red flag right there. What do you mean we haven't done any screening or we haven't had any issues in the past? Everyone has issues, and the government understands that, especially from small businesses. Being a small business actually or inexperienced export is actually a mitigating factor if things go wrong and you self-report. But you want to put yourself in as good a position as you can to do it right or as close to it the first time.
Absolutely. Rachel?
The only thing I would add to what John just said was have a process and stick to it and make sure that that includes documentation. And I also think, to John's point, when you have then something to say, we have a process that we need to go through, and we have some boxes that we need to tick. And I think it's important to stick to that, to make sure you go through the process from top to bottom and document it.
Well, thank you again, John, Rachel, and of course our own Dr. Mercedes Sanchez Moore. We will shut down for now, but we wish you a lovely rest of your day and would love your feedback in that survey that is about to show on your screen. Have a just fantastic rest of your day, and remember to do your homework when it comes to export compliance.
Thank you,
Bye-bye,
everyone.
everyone.
Thank you, everyone. Thank you.
Bye now.
Bye-bye.